All right, this will be the People News. One more time at it. Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. Okay? Use your Second Amendment rights. Arm yourself with knowledge. And never go by hearsay. Do your own research. Okay? That's one of the ways you protect yourself. Okay? Attorneys are hearsay. Judges are hearsay. I'm hearsay. Cops definitely don't even know what they're talking about. And just saying, you know, when you find out the judges and attorneys are criminals and you go file a criminal complaint on judges and attorneys, do the cops arrest the criminals? No, they don't. Okay? Vice versa. If you file a criminal complaint on a cop, do they actually do anything? No. But it's always good to do it because if we all start doing these things, then the courts will have to actually start paying attention and waking up and realize that we, the people, is wising up. Okay? We have not stayed as little sheep, and we actually became black sheep and grown up into wolves. All right? Let's go, because this is going to be a little bit, probably going to be 2 more videos, but we're at towards the end. I know, celebration, right? Just a reminder that he did have another court date, but what do? They hid it from you. That's what they did. Remember, tyranny and treason begins behind closed doors, people. Just saying. If it's all out in the open and they called it out exactly what it is, then we can actually go up there and say, no, we disagree. But they do it under a color of darkness. And then they say, vote for these 3 laws, and all 3 of them you don't want to vote for. But you only had the 3 choices, right? But I've read some of them. I didn't want none of them. Well, why in the world would I vote for any of these? And most people will. Because they seem to think that's the only options they have. That's just the only ones they provide. We, the people, need to say, no, and call them and say, no, this is not okay. Let's go.
August 23rd, 2023, while driving a motor vehicle and having been given a visual and audible signal, a uniformed police officer to bring the vehicle to a stop, willfully failed and refused to immediately stop and drove the vehicle in a reckless manner while attempting to immediately pursuing the police vehicle that was equipped with lights and sirens, contrary to RCW 46.61.024 and against the peace and dignity of the state of Washington. I ask you to enter a plea with this.
You want to enter a plea at this time?
I'm actually innocent.
And so I will enter a plea of not guilty on your behalf.
There we go. There we go, people. I'm going to put in there, not guilty. Now, what is it? Lathrup's Law, all right, described innocent and not guilty being 2 different definitions. Now, I've been saying it for years. It's just finally an attorney actually put it out on YouTube for me to videotape and tell you guys. So kind of go back there. I don't know how many videos back it is, but it was pretty recent. So it's probably less than 20 videos back. So if you guys want to check that out. But innocent and not guilty is 2 different definitions. Right? And there she is, right? Argument's sake. Because I'm not 100% what happened. I just know of him because he's been fighting cases for 4 years. And he's on Telegram. And all that kind of stuff, right? It kind of went blank there for a second because we got to be clearly understanding these things, right? We are presumed innocent. You don't have to check the box and say not guilty, no contest, or guilty. Because you are presumed innocent, people. Now, we became a creature of habit and not paying attention and just keep complying. Meanwhile, what are they doing? Every single day, violating your rights, violating due process, and whoopie-doo. I'm sorry, kings, queens. I'll bow down to my masters. I shouldn't be doing these things, right? Some of you guys, I told you guys, a couple of years ago, I haven't had a ticket in a while. It's been 4 years ago since I had a ticket. But when I went in there, I marked all them out. And I put a little square box in there and checked it and said, actually, I'm going to start put presumed innocent in there. But what I did is mark checkbox, write in innocent. Okay. So I shouldn't want to follow. I always tell you guys, never make a claim, right? But I did. I claimed I was innocent. But I think, in all actuality, you guys think about it, okay? It may be the best route to put that checkbox in there, right in there, presumed innocent, because that's what they tell us, right? We're presumed innocent. Anyway, I digress. But she's going to put it in there, and she is actually acting as his attorney. Okay? And I would challenge that. So, okay, well, I may go ahead and accept your offer, you being my attorney, but we're going to have to enter some form of contract. Let me wind that back.
Pursuing police vehicle. That was equipped with lights and sirens, contrary to RCW 46.61.024 and against the peace and dignity of the state of Washington. Ask the owner to plead with this.
You want to enter a plea at this time?
I'm actually innocent.
Okay. And so I will enter a plea of not guilty on your behalf. All right, Mr. Benson, I think we do have a time of August 15th, so in about a week.
Again, right there, I think you missed an opportunity. I do not accept your offer. I deny that claim. I'm not guilty, right? When you deny it, you actually put the burden of proof back there on their behalf, okay? So I think you missed an opportunity there. Now, remind you guys, this is educational, okay? I'm hearsay. I'm not an attorney, right? Not giving legal advice. I got to cover my ass. Somehow or another, I filled out a bar card saying I'm going to comply with them.
Time at 3 o'clock for your motions to dismiss to be heard more fully.
Okay, and there's an issue that I ran into yesterday, which has hopefully been rectified, which is that the DAJD has not been providing me any computer access, no printer access, anything. So if the court would please issue an order clearly stating to the DAJD that I am pro se litigant and that I should be afforded all of my pro se materials, computer access and printer access, so that they can't any longer say that I don't have the right to be that.
Sure. So we are going to do an order that says you're pro se, and we can get you a copy of that order so you have that information. As far as directing DAJD to allow you to have computer access and printer access, I can't really do that without their lawyer present as well. I can't pretend that I remember exactly what the booklet for DAJD says about your rights now that you're representing yourself, but my understanding is you will have some rights to be able to use those, but I wouldn't do an order.
Okay. Some rights. Okay? If they're limiting him, that is a violation of due process. Period. Your Honor, that's treason. That's not tyranny.
We're going to entertain a motion on that just yet without their lawyer being able to request. And when
Understood. And
okay, yeah. So we'll make sure that order that says that you're representing yourself now will get sent over to the jail, and so they will know that for all the different things to be able.
okay, and I would like to move for the release of myself on my own personal recognizance.
Okay, and we've got to set that for a motion too. All right, but we'll make sure that we set that. Do you want to do it at the same time? That's right. Yes. So we'll set it at the same time as the motions to dismiss on the 15th.
Okay, and last question is, I have not been provided from the prosecution the complete search warrant documents for SW 24-0-62121-3. I would love, if the prosecution has those today, I would like copies of them, as well as I need copies of the search warrant that was allegedly obtained by SPD detectives for my cell phone ping data, which is mentioned by SPD Detective Ryan G. Ellis on page 9, paragraph 3 of Ellis's certification of probable cause, which was included with the county's information filed on July 8th of 2024.
So, Mr. Benson, you are going to be entitled to all the discovery in this case, including any search warrants that are directly related to this case. I don't know whether or not those numbers of the search warrant are directly related to this case.
There.
But if you want to bring the motion on the 15th to include the motion to compel, which would be to compel this public discovery, then you can do that as well. But the state does have discovery obligations to provide you with all of the materials that are relevant. And if you think you're missing something, you got to give them a little bit of time to get it to you, right?
Well,
but if you think you're missing something, then you can ask the court to compel them to do that.
Yeah, so as part of that motions hearing, I'd also like to include an evidentiary hearing pursuant to Franks v. Delaware, Supreme Court 1978, to challenge the validity of the search warrant.
Okay, well, what we can hear is next Thursday is whether or not you're entitled to a Franks hearing. You don't automatically get a Franks hearing with it. We can talk about that. We won't have the ability to do a full evidentiary hearing next week, but we can talk about whether or not that's something that's appropriate to order or not. All right.
Thank you.
So it's a pretty ambitious schedule for your hearing. So it may be that we're not able to do all of it. Then, so think about in your head what you want to prioritize, and make sure that if you have any written materials for your motion, that you get it to the prosecutor in advance.
I will if I'm afforded that possibility.
Okay, understand.
If I'm not, then I would, of course, claim if once again that my due process rights have been violated.
All right.
Thank you, Your Honor.
We're going to be done for today, but we'll see you next week.
Good. Sorry, the state's going to ask the court to set conditions of release.
I'm sorry. Yeah. Okay.
And we have to set the new dates for warrants.
Okay. So what are the conditions of release?
Yeah, the state's asking for maintain the previously ordered bail $500,000 and have no contact directly or indirectly in person, writing, or by phone, personally, or through another person with Jessica Owen, Miss Owen's children, Magali Lerman, and then he have no law violations, keep his address updated in court, appear at all future court hearings pursuant to criminal rule 3.4 straight, maintain contact with counsel.
And Mr. Benson, I just want to say I was wrong about your ability to ask for release today. Given that we've seen you a couple times, because we are just doing the arraignment and the state needs to set conditions of release, you do have the ability to ask for release now. And Mr. Lavin, I'm sorry if I cut you off. There was something more that you were asking for your conditions.
Just the RCW 1099 order prohibiting Mr. Benchu from having any contact with Jessica Layline. I do have a statement from her. However you want to come.
Why don't we hear the statement from her first, and then Mr. Benchu, I'll hear your request to be released.
Your Honor, I would object to the reading of a statement by Jessica Ray Owen, who's a pathological liar, who I've already evidenced in numerous court cases, committed perjury without me being afforded the opportunity to question her here.
Sure. Just for a bond hearing, we're allowed to hearsay for it, and alleged victims do have the right to be able to be heard either directly or in this fashion. So I'm going to overrule that objection and let Mr. Lavin continue.
I had to pause that right there, quick, right? We're allowed to have hearsay, okay, from someone making a claim, but there has to be some form, affidavit under penalty of perjury and all that kind of stuff, and they're allowed to do it in private, which I disagree with on that. He's still allowed to argue his case, even that case. just because he's sitting in jail over this. Just saying. Maybe. Okay? That part's out of my league.
The opportunity to be released, I worry that he will only escalate further. He has engaged in patterns of violence that put me in and simply share in danger. Kurt has no regard for you, the police report. He has stalked me, harassed me, and used our son to gain access to my life. I ask that you please keep his bail to not have it currently set forward, and that you issue an NCO as a safeguard. Your Honor, I am terrified of Kurt and what he might do next. If we release him, I will have to take my minor son to disrupt his.
Alrighty, people. I'm probably going to slide this back a little bit. What are we at on this? We didn't get very far because of my rambling. Sorry. This will be the People News.